Good afternoon, everybody. Boy, that was quite a wake-up call about the Oso landslide. This is kind of a different issue, but there are just as many pitfalls in it. And fortunately, most of the rules concerning the settlement of lawsuits, the ethical issues, are fairly apparent. But once in a while, something comes up. And once in a while, it's well worth our time to remind ourselves that even though the lawsuit is over, the last thing you want is this thing being resurrected at some point because somebody did something that wasn't quite right. And I've got an example at the end of my materials where I nearly walked into that trap myself. So this was near and dear to my heart when Ed asked me to speak on this, and we'll get to that story. So I've divided the segment, this presentation, we only have 20 minutes, into three different parts. Where's the clicker? There we go. Who can you talk to? What can you say in settlement negotiations? And what terms can you ethically negotiate? Because that's always the interesting ground, because most of us are involved in settlements that frequently that aren't really routine. They're novel, they're atypical, clients have special needs. They try and negotiate certain terms to buy the piece that they need, to pay the money and the value to the other side. So that's always an issue, that's always an area that we need to be thinking about. So who can you speak to? I'm not going to spend a lot of time on this. It's Model Rule 1.2a. You can't settle a case or plead out a criminal case without talking to your client. So we're going to jump right ahead. And I want to focus on what the Model Rule 4.2 says is, you know, when you've got represented parties, there are certain rules that govern, right? How many of us have had a situation where you convey what you think should be the settlement offer that ends the case? Hey, we made them a really, really fair offer, and we don't hear anything back. And we have doubts about whether the other side conveyed the offer. I've had that all the time. Did you actually convey the offer? Now, this is surprising. There's an ethics opinion that says you really can't ask the other side whether the offer was communicated. You can't call up the lawyer and say, come on, did you even communicate that thing? Why didn't this case end? You can't do that, according to this ethics opinion 92-362. Now, what can you do? You don't really have to sit back at that point. There are things you can do ethically to try and keep the ball moving. You can advise the client that it is your belief that the offer was never communicated. You're allowed to do that. In fact, you should do that. And you can advise the client that they, as a party themselves, can reach out to the other party and ask about the status of the settlement. You can do that. And in fact, you can advise your client to do just that, to break that logjam, because you can't ask the other side's lawyer. So what can you do? And you see this happen, business to business lawsuits. Sometimes they say, look, we think we can get this done, let's get the lawyers out of the room. Or even in divorce cases, sometimes the parties are still talking and they want to get this thing done without paying a lot of legal fees, so they want to talk among themselves. And as lawyers, we ought to be encouraging that. So what can you do to help in that process? The two parties are talking. Can you prepare documents to help in those party-to-party negotiations? Yes, you can. Can you prepare talking points? Yes, you can. Can you prepare a draft settlement agreement in the hope that the case will settle? Absolutely, you can. What can't you do? Now, there's an ethics opinion that says you can't overreach. And what they define as overreaching is, in the context of these party-to-party communications, you can't encourage your client to try and secure a key factual admission. You can get them to give up key negotiating points. So you can provide substantial assistance in these party-to-party negotiations, but with the caveat that any offer or any stipulation has to be run by the other side. So I've had this come up, and the parties were talking. It was great. It was very exciting that they might actually get this deal done because we couldn't get it done. And so every time we put something out in writing, the client put something out in writing. We made it really clear that, look, before anything happens, you better get your lawyer to look at this. Because otherwise, if they make an agreement, and sometimes clients will do this, reasonably sophisticated clients will make a deal. And you can't do that if they're represented. The ethics opinion says you absolutely have to make sure that they have been advised in writing to run anything by their lawyer. So what can you say? This is always sort of entertaining, but more or less fairly obvious, I think. You can't make false statements of material fact or law. Okay, there's no clear definition of what that means, so we've got to exercise our judgment. And Model Rule 4.1 gives you some guidelines. You can estimate what the value of the case is. I mean, you can say all day long, I think there's a $5 million case, and I think you guys should settle it because the jury is going to give us $5 million. You can say that. You can absolutely say, my client, your client's intention to settle, you can talk about that. My client has every intention of getting his or her day in court, and we're going to do that. That's totally fine. But what you can't, and you can puff all day long, like I said, what you can't do is you can make up stuff. You can say, I have witnesses who will testify that X, when you don't have those witnesses. Or you can say that, I haven't looked at this, but I'm pretty sure that the law is, X on this issue. There's no caps on damages, whatever it is. You can't make up anything that relates to a material fact that could induce a settlement. What about your bottom line? That's always an interesting issue because everyone wants to know your bottom line. Well, what's your bottom line? We're trying to get a case settled. And you've got to be careful with that one. You've got to be careful with that one because this ethics opinion 93-370, it's very clear that your settlement authority is a material fact on which another party may rely to consummate a settlement, and that is a decision that is entirely controlled by the client as to whether or not that is disclosed. And so if you say, look, I don't have authority to settle this case for under $5 million, that's okay, regardless of your authority. You can say that. What you can say is the board of directors has passed a resolution that we will not settle this case for less than $5 million. Because that is a material fact that you just made up if the board didn't pass that resolution. So there's that line between creating a fact and sort of puffing up your position, and this opinion recognizes that. So your willingness, your goals, we're going to settle this case today or we're never going to settle it, even if it's true or not, you can say that. That's just fine. Today is our last day. As of this evening, we're going to be preparing to go to trial. How many of us have said that? You can say that all day long. But you can't say the board has passed a resolution. The case doesn't settle. We're going to trial on Monday morning. Now, I have had this happen, and this is uncomfortable. And there's an ethics opinion on this, 94-387. You're going to be in a room with a mediator at some point, and sometimes you'll be in the room with a judge who has taken upon himself that he's going to get this case settled because the magistrate couldn't get it done. And he says, do any of you have a problem with this? Sometimes we say, yes, we do, and sometimes we say, no, we don't, Judge. Let's see if we can get it settled. And I've had federal judges call us all in and say, look, I'm really disappointed with this magistrate, but I think I can get it done. We'll be done today. You guys want to let me take a run at this. There's no motion spending. There haven't been any motions filed. You may think about those things, but in any event, you may have a judge at some point say, well, counsel, this is between you and me. You're in a room with a federal judge or a mediator for that matter, particularly a judge, and he says, it's between you and me. I'm trying to get you to get this deal done. What do you got? What do you really have? I've heard what you say you have. What do you really have? You can't do that. Now, the client may consent to that. You could ask your client, should I give him our bottom line? I would never ask a client that question. And so you wouldn't maybe think of doing it. Because the judge will frequently take you outside, right? Outside the presence of your client and what you got. So That is very dangerous because you are violating all kinds, even though your intention is the client's interest to get the case settled. You have a duty of confidentiality, 1.6 under the model rule, and you have the duty of diligence, 1.3. And those have been jointly interpreted to say that you cannot disclose the bottom line of your settlement authority absent client consent, no matter what that judge asks you to do. So the correct response when you've got him or her asking you what your authority is, if you don't have the authority to disclose it, you just simply decline to answer that question. That is the only way around it. Judge, I'm not going there with you. I can't. That's kind of a sticky wicket, and that's something I have to sometimes remind myself when I'm in a settlement discussion, because we all become extremely familiar with the mediators we use. The JAGs and the JAMs of the world, we all have relationships. They trust us, we trust them. They're not going to breach anything, but just the disclosure on your part is enough to trigger a breach of that duty. So I think that's grounds that we need to be a little bit sensitive to. We do have the duty, there's certain duties, we have duties not to disclose, right? We do have a duty to disclose the death of a client. I'm sure most of us don't really have this situation in this room because we're all doing defense work, but I wondered about that. I was like, well, yeah, I guess because, and I had to read through the rule, this ethics opinion, and it's because when the client dies, the plaintiff lawyer doesn't have a client, and he can't assume that he represents the estate. He just can't, so that's something he absolutely has to disclose, and I think most of them do disclose that in a timely way. You don't have to disclose weaknesses in your case, right? You don't have to disclose it, and actually there's an ABA opinion on this, and I'll digress because it really is surprising. The question was whether or not you had to disclose that your client's claim was barred by the statute of limitations. Do you have to disclose that in a mediation? I mean, I wouldn't think you had to disclose that in a mediation, but it seemed also a little bit uncomfortable that you would be prosecuting a case that was based on facts that were barred by the statute. So what position did the ABA take on it? And this was, not surprisingly, so there was a dissent in this opinion, which the ABA almost never has in these ethics opinions. And the conclusion was, no, you don't have to disclose that your claim is barred by the law. You don't have to disclose that because you have a duty of zealous advocacy. And so you don't have to disclose that. The dissent was very perturbed by that because, for obvious reasons, I mean, you can't have lawsuits necessarily based on close to what I would consider fraud. But the dissent made a point of saying that this was in the 90s, and they said, we are in the 90s in the midst of a campaign trying to improve the image of lawyers across our country. And these are exactly the sharp practices that do damage to our profession. And it's true. I mean, in my view, it's true. I don't remember, we all lived through those commercials disparaging all of us in the 90s. They seem to have stopped, thank God. But that was an interesting opinion because I guess you can go into a mediation and argue like hell for top dollar and that you're going to trial when you know that your case could well be dismissed at any time on a motion. So this is one that we hear about all the time. You've got a great plaintiff lawyer on the other side. And I think this is very well settled by now. Can you restrict his right to practice? I think every jurisdiction has said, you can't say, Mr. Panish or whoever it is, you're not going to take any more of those side saddle exploding fuel tank cases, right? You're going to put that in writing. That's just not going to happen. You can't do that. You can, in Colorado, ask whether he plans to file any similar cases, but that's, as the Colorado ethics opinion said, that's pretty close to the line. Even asking him about whether he has a present intention to file similar product defect cases or any cases is close. But there's, the most important thing is you cannot in any way bind a lawyer's prosecutorial authority, is the term. And what that means is you cannot say, all right, we're going to enter into a settlement. We know we can't stop you from bringing these cases, okay? But here's what you're not going to do. And this is also in the Colorado opinion, you're not going to subpoena this group of documents that's really good for you, right? So we'll put that in writing. Can't do it. You can't say, and you're not going to bring this case in Holmes County, Mississippi, right? We're going to have a venue of, Denver, which is conservative. You can't do that. You can say, you're not going to ask for another 30B6, so you're not going to explore this issue in a deposition. Most of us know that instinctively that you can't do that, but somebody thought about this because there's an ethics opinion on it. And either they thought about it before they entered into the settlement or after, but they thought about it. And so we have some guidance about binding somebody's prosecutorial authority. So that's good to know, because you will have a client who will say, we're paying $5 million. This guy's not going to bring any more cases against us, right? Tell me, have you guys ever had that discussion with a client? I have. We're paying all this money. He's going to bring another case tomorrow. How can we settle for that money? Can't do anything about it. You really can't do anything about it. So, can you say, okay, Mr. Plaintiff Lawyer, you did a really, really good job with these 3 documents. You're not going to tell anyone about those 3 documents. Can you do that? Yeah, you can do that. There's a protective order in the case. And you're allowed to abide, and he's required to abide by the terms of the protective order. So you can absolutely require him not to tell anybody. If you've got a non-sharing protective order, he can't tell anybody else. You can hold him to that. But you can say, and those 3 documents, you'll never use them, right? In the next case, that's off limits, because that limits his prosecutorial authority. We've talked about identifying other clients. Colorado, Arizona have guidance. Colorado says yes, Arizona says no without consent. We've talked about the destruction of documents. So what about the affidavit? This happens a lot, I think. Client says, well, okay, we're settling with this co-defendant over here, right? He's got some stuff that's helpful to us. We'll get him out of the case, but he's got to testify, right? You're going to make him testify. And he's going to testify about what he told you in that interview, right? That's why we're paying him this money. Or we're going to take over his defense. Can you do that? Yeah, you can say, sure, we're going to condition the settlement on you testifying. We had a case 3 weeks ago in our office where we got an affidavit from a settling co-defendant, and they grieved us over it. We won. The judge threw it out right away. He said, you can get an affidavit from the other side, from anyone you settle with. That's just false. You can't get what a Texas opinion called an acceptable affidavit. We'll settle with you if you give us an acceptable affidavit. You can't do that. You can say, we'll settle with you if you give us a truthful affidavit or truthful testimony at trial. But you can't condition it on particular facts on which you're relying or on which your defense may rely. You can't do that. So as long as there are no conditions placed on the testimony, be it by affidavit, be it by live testimony, deposition, or statement, you absolutely cannot try and precondition your settlement on certain testimony being provided. This is the one I want to talk to you about, because this really I almost got bit by this. So I'm coming clean on this. So what happened? We had a PI case, and the client said, I hate that plaintiff lawyer. He's a snake. I don't trust him one bit. This is a PI case. There was a Medicare lien. Okay? MMSA was involved. And they said, this guy's going to take the money and run. And he's going to leave us with that lien, because we have to disclose the settlement to MMSA. So he's going to leave us with this lien. So be really, really careful. So it was agreed that we would try and seek an indemnity from the plaintiff lawyer. And so I called him up and I said, hey, I've got an idea. Let's sort of make this go away. I think you're going to do the right thing. We've got some concerns given the way this lawsuit has gone. Why don't you give us a personal indemnity? And he freaked out. And he said, I can't give you a personal indemnity. I mean, well, there's a lot of money. I can't do that. I'm going to have to pay the lien on behalf of my client. I can't give you an indemnity. And I said, you're being really, I think people do this all the time, don't they? And then that little gut feeling, when, that feeling in the pit of your stomach that you sometimes really wish you had had, I started worrying about it. And it was bothering me. And I said, I got to research this. Because this guy was really upset. And fortunately, he wanted to settle the case, and I've worked with him before, so he never raised an ethical issue. He just said, I can't do that from a practical standpoint. And the client was very legitimately concerned that that's something we had to get, because the penalties, as you all know, if the MMSA settlement isn't disclosed, the lien isn't resolved, we are liable. And so we researched it when all else fails. And this is what we found. There's one ethics opinion in the country, and it's in Virginia, and it says you can make him indemnify you as the defendant, the settling party. You can make the plaintiff's lawyer indemnify you on this very issue, on the payment of an MMSA lien. Not going to happen. Why? Because then he's providing financial assistance to the client under 1.8. You have a conflict. Because presumably he's providing financial assistance. He doesn't want to do that. He doesn't exercise the best judgment in resolving the lien. He maybe pays too much money to Medicare and Medicaid. There's all those kinds of issues. So when I found that out, I told, the client, of course, was like, stop, absolutely, do the right thing. And so we wrote a letter saying, oh, by the way, we asked you to do this. We absolutely are not asking you to do this, because we've looked into this and we think it would be completely improper. And, to the extent that you've even considered it, it was an error on our part, which it was. It's off the table. And we ended up settling the case. Everything was resolved. And, I think it's all done. And so that is something, and it's something new. And so I thought I'd bring that to your attention, because MMSA is something that does keep me up at night when I do PI cases. So something to think about. But thank you all, and enjoy the city.